Welcome back. Thom Hartmann here with you. This was yesterday, I guess, but about 40 minutes after Supreme Court. This is Ian Millhiser writing over at the Center for American Progress's blog, Think Progress. About 40 minutes after Supreme Court nominee Neil Gorsuch began his second day of testimony before the Senate Judiciary Committee, all 8 of the justices he hopes to join said in a major disability decision that Gorsuch wrote in 2008 that he was wrong. Now, back in 2008, there's this thing called, it's called IDEA. It's the Individuals with Disabilities Education Act, IDEA. And what it says is that if you're a public school and a disabled child comes into your school, that disabled child, regardless of their disability, is entitled to as good an education as anybody else can get, even if it means that you, the school, have to, spend a little extra money. Now, the conservatives don't like that. Right? What? Spend extra money for disabled people? How dare you? We can't have that. And so the job that Neil Gorsuch had was to figure out a way to screw disabled kids, to ruin, to deny disabled kids access to a full and complete education, and yet still keep the law in place, because he couldn't strike down the IDEA Act. I mean, that's something the Supreme Court could do, but. So what he did was he invented a new legal doctrine. He hatched this out of thin air, this guy. Which, by the way, is kind of, you heard Sheldon Whitehouse in the last hour talking about Citizens United and how those guys, and the 5 Republicans on the bench in Citizens United, they didn't even decide the case before them, which was very narrow. They instead asked everybody to come back and argue a much wider case, which is something the court should never do and historically, to the best of my knowledge, has never done. So they're just, they're literally, these are court-created law. This is not calling balls and strikes. This is not, judicial conservative judicial behavior. This is active legislating from the bench. And so the new standard that Neil Gorsuch came up with is that he called it the de minimis standard. That if a disabled child is getting anything at all more than nothing, that meets the requirement of the law that they have a comprehensive and complete education. The exact phrase this is, what he said was that educational benefits must merely be more than de minimis. De minimis is a Latin phrase meaning so minor as to merit disregard. So Gorsuch, Ian Millhiser writes, essentially concluded that school districts comply with their obligation to disabled students so long as they provide those students with little more than nothing. Chief Justice John Roberts, conservative Republican John Roberts, writing for all 8 justices, his other 7 colleagues, all 8 justices on the court, wrote, and I quote, "A focus on the particular child is at the core of the IDEA program. The instruction offered must be specially designed to meet a child's unique needs through an individual education program, an IEP." They threw out Gorsuch's attempt to create a whole brand. He's doing the same thing his mother did at EPA back from 81 to 83 when Reagan put her in EPA to tear down the Environmental Protection Agency, and she had to resign in the middle of a scandal at 83. Just pulling stuff out of his backside, creating things out of whole cloth to satisfy the Republican goal of how dare you spend my tax dollars on that disabled child? Not my disabled child. Meanwhile, Republicans want to make sure that pregnant women, if they're carrying a disabled child, don't know it. It's not a child at that point, but which is bizarre.